It can be a demoralizing experience to be discriminated against in the workplace simply for belonging to one of these protected categories for which no one has any control over. Before you contact an attorney, if you are experiencing any of these issues in the workplace, there are a few things that you should do. Today, I'd like to discuss what counts as discrimination in the workplace. First, let's define discrimination. Discrimination is the unjust or prejudicial treatment of an individual based upon them belonging to a protected class. We will discuss those categories later. I'd like to start with some examples of what is not included in a case for discrimination. For example, if you're having difficulties getting along with your boss because he or she is just unbearable, that does not qualify for discrimination in the workplace. If you have a boss or a supervisor who yells a lot and is verbally abusive, that alone does not qualify for discrimination in the workplace. Another example is a supervisor who puts down your work or berates you. That alone does not qualify for discrimination in the workplace. So what does count as discrimination in the workplace? Let's start with some of the protected categories under the Fair Employment and Housing Act in the state of California. Examples include race, religion, ancestry, national origin, color, physical disability, mental disability, genetic information, medical condition, marital status, sex, gender identity, gender expression, sexual orientation, age, being over the age of 40, pregnancy, childbirth, or other related medical conditions, military and veteran status. In addition, any employee who has been retaliated against in the workplace for belonging to any of the above protected categories also qualifies for discrimination in the workplace. It can be a demoralizing experience to be discriminated against in the workplace simply for belonging to one of these protected categories for which no one has any control over. Before you contact an attorney, if you are experiencing any of these issues in the workplace, there are a few things that you should do. The first one is documentation. It is so important. If you have any email evidence, text messages, photographs, any video, it's important to retain all of that and to keep a copy and forward it on to an attorney in the event that you end up having to retain counsel. Notice is also extremely important. It's not enough that you talk to a coworker about what's going on in the workplace. In order to hold the employer liable, you have to notify upper management and the HR department. If there is no HR department, you go to your manager and you report it in writing what you are experiencing. It's important to leave a paper trail. If you're part of a union, it's important that you let your union representative know what's happening because you are subject to what is called a collective bargaining agreement, and it lays out very specific and definite timelines that you have to follow in order to bring a claim about treatment in the workplace. Once you have reported to your supervisor and to HR, and if things are not improving in the workplace, it's now time to talk to an attorney. If you live in California and you'd like to get more information about your options, please feel free to reach out to me for a consultation, and I'd be happy to talk with you. Thank you for watching this video. If you liked it, please feel free to leave any comments and also like the video. If you know anyone who could find this information helpful, please forward it on to them. And if you'd like more information about other employment law topics, please feel free to subscribe to my channel. For everyone else, I'll see you in the next video.